Oh, and the procedurals on top. Sorry. Is it all right?
First, we set the economic, non-economic distinction. This is across the nation. Across the counter-interpretation, we should just specify one of the grounds for which Marxism is overturned on either 14th Amendment Commerce Clause. This is good. The ace point guarantees counterpoint. You counterpoint out either one of them any ground. B point data limit. They make it so the affirmative can specify a test. It's not even grounded in the literature, e.g., congressional deference. C point safely to an infinite amount of abuse of things. So we'd have to specify what ground, especially when they can pull one out of thin air. They also do not have any evidentiary standard for the real world standard. They claim to do cross-examination of ground prep. Also, check if use the punishment doesn't fit the crime or worse. Give them some leeway. Don't make us lose around on advanced treat. They said the poverty leads to social control. This is an interesting historical FYI. It says after World War II we invented poverty in order to have social control. There's no impact to social control. A reason that we would do so in Sasco. They haven't seen a piece of binder evidence. A straight up impact to their criticism indicates that economic calculations are good in the context of gender violence because they provide monetary restitution that is critical to the value of life and overall happiness. They say that we do not indicate how much our buy evidence indicates we are keeping an educated workforce and our buy evidence indicates is critical to solving all types of poverty. This is impacted by the binder evidence. That was explained above advantage 1. They say that there's no money that they would be able to have. This isn't true. Our sailor evidence indicates there's a whole litany of things that will come in the status quo that will not be able to help reach women because of the Morrison's here. And our piece of Johnson evidence indicates the Supreme Court is critical on this matter. Additionally, our first piece of Goldberg evidence indicates that they do have other forms of financial resource, civil rights when they can solve, and many suits are reported, so they don't need money. Davison won the 50 reported case, maybe the tip of the iceberg, and that there were certainly more cases that were not reported. There may be cases that were not even probably because the laws in the books encourage settlement for the case of violent powers, the victim situation go directly against the perpetrator of the violence and way that she otherwise would very concluded from doing this. Very well effective encouraging states to do a better job and has an impact to potentially avoid and deterring some of the violence and deterring some of the lawsuits in the first place. And other avenues of restitutions are all advantages to the affirmative. A civil remedy allows progressive forms of criminal institutions, Razi, and 93 civil rights actions for reform in other areas of the law, such as the criminal justice system, local legislatures, blind to the challenge of national anti-discrimination standard by enacting more effective statutes enforcing the doctrinal development of all ways for development of civil rights actions. The court can apply beyond all court developed tests to understand the problems of new field law and such in the application of law may revitalize civil rights instruments. And other areas, they say that the card evidence is indicative of the overall law, why not the civil rights remedy. We do not appeal to the middle white women. Our Amnesty International evidence indicates it's a catalyst for all the forms of repression. They say that tort law is bad. This is spread by our binder evidence indicates that tort law is empowering more. This will be read on the criticism and civil rights remedies necessary to deinstitutionalize violence and change the public opinion of a routine issue to an endemic problem. Crossing 93 these civil rights action will expose the common analysis of pervasive violation. One of the most powerful tools for sustaining oppressive institutions, especially violence against women, is the ability to atomize a person's experience, keeping powerful social lines. So part encouraging those who experience violence to internalize mental circumstances. A routine civil rights remedy will expose the interconnectedness of gender motivated violence. They say Miller both affirmed this is Miller and 5 foundation civil rights remedy provision leaves intact the rest of all the permanent sense of provision from money crime prevention provisions yet again offensive to victory for national policy for the protection of women transfer needs to expand the crime control apparatus. These states additionally did not lead to military intervention. The cross-examination on this question was embarrassing. They say the public-private values prescribed by McKinnon evidence indicates that the Morrison decision public submit to the public-private economy is a catalyst for gender violence is also inevitable, and we only allow a choice for this to happen. They read the piece of Glick's evidence is unresponsive. They concede a piece of King evidence indicates that their alternative would not be able to solve the case because you cannot get away from domestic violence without the help of the state. Sometimes if somebody is beating the crap out of you, there's no way to escape it. And advance they read a piece of Luke evidence. Luke goes affirmative. Luke in 97. The soldiers are coming to the trafficking door saying you could use police, but they do not have a practical group in political actions. This place in the realm like critical ideas making every individual more ability to change himself or herself and advancing cultural change without the opportunity to change collective action. This one personal world regeneration might become only quite as simple as modern as the talisman finding the right path of an evil society. Such principles have little practical utility for staging ecological revolution, and Luke includes the institutional changes necessary to stop extinction. Luke in 97 only the action for those significant positions of decisive managerial power and government can truly do something to determine the future belief that the last roots will place a life or towards the ecologically improved alternatives can decide to affect the survival of the species of pure ideology based on new kinds of toys, but it does not guarantee planetary survival. And read a piece of clone evidence. We do not say that some places are more important than others. They've also conceded a piece of strict evidence indicates that we would solve for the entirety of the environment. Our chosen evidence indicates that this goes global. They say apocalypse burn or bad. Human existence. Extinction representation breaks the title, nominee, create hope, lifted, and 99 survivors to match with death and can order created past this end and used in a movie on you must imagine in the world no more to prevent the psychological handle of death as a continued life or civilization who we connect us after decades and enemies begin to break down the kind of collective racial collusion, not feeling what happens at the other end of the weapon, and there's a movement now towards awareness shift to constant quiet, hopefully and apocalyptic imagery is good by showing how current institutions will catalyze the social change. Kurosawa went for this, if foresight is direct outcome of the transition towards the dystopian new imaginary, the catastrophic sensibility need not apply. response, you can also fear quite the opposite. In fact, since it's based on this utopian imaginary canal notions of historical and helps gain traction against their determinants and absolute counterparts. Once we recognize the future is uncertain, the course action produces both unintended and the consequences of responsibility face up to potential disasters and even before they strike become additionally just all inevitable because they've not solved the gravity. They say that we do not add species to the list. This is true. Our circular evidence syndicates we solve current species that are UCS evidence syndicates. Those are keystone species. They say we don't have good evidence. I'll challenge them on this question. I think we have phenomenal evidence. They say our diner evidence is bad. This is true. Diner evidence indicates ecological destruction risk. Human extinction. They concede a piece of Darby evidence means the alternative doesn't solve the case because micro-political changes cannot challenge institutional structures. Our Lewis evidence indicates that individual solutions ultimately fail because it's only the institution that must be changed, and the individual solutions ultimately fail to challenge the institution because they say we should not work with it, which is the only hope to change the criticism. First, torts are better than criminal law, allows them to settle before court and have no statute of limitations. We believe and six, the civil actions of benefit so proponents evidence only controls to be filed after criminal acquittals of benefit and seek to discover and compel the defense testimony or drive person inferences from the defendant's choose to lie. The defendant toward action has no right to free legal representation. Many current cases the plaintiff settle with it jail before the trial. Commodification is inevitable. There's no reason that the gender violence is critical, and this is one big inherent contention. Their evidence indicts a lack of federal intervention. Pope and to get to the Commerce Council begins to correct one half of the distortion caused by the lawyers failed to transmit the popular movement to human rights. The infinitely expandable Commerce Clause. Now, human rights statutes that are not really as classified as commerce exercise of the Commerce Clause, they may fall outside the scope of congressional power altogether, which proves that our entire affirmative is a diss at to them because their alternative would ever preclude us going to the government. And their Pope evidence is not causal. It indicates we should not view women as non-economic. Our plan does exactly the opposite. Pope and two, Norrison's court's categorization of violence of women as non-economic is indefensible given both the painful irony that the court has many times acknowledged that women can be treated as commodities. For example, the Mann Act and these simple points of economic rights to women's equality and freedom are elder evidence indicates that all micro-political challenges would not be able to solve. As it also needs to this, the criticism would also not be able to solve things like our environmental advantage because they would just have micro-political rethinking, additionally permutation, do both, and towards solving animus and avoid monetary calculation, bad arguments. Movement can 6, the element of force is irrelevant as long as the victim can prove defendant had actual harm or offended to control the decisions. Attention to litigation including when and whether to settle or dismiss case victims to shape litigation to meet their personal objectives. For litigation may be filed with intent to obtain monetary damages. The sales will have the assets and income from which to pay a judgment toward suits can aid victims to obtain monetary objectives such as an apology. They say let's transfer these litigation objectives may be easier to achieve and control that because victims can directly bargain to drop pursuit in return for the defense promise to meet her interest. This also means it's the case argument that you would not be able to have the money to do so because our evidence indicates you can ask for other things in the first place. The counterplan, first permutation due to the counterplan, it's not textually or functionally competitive. There's no solvency advocate for the counterplan. This is a generic argument. Literally, there's not a single piece of evidence that advocates that we should return the Commerce Clause powers to the Supreme Court, except in the case of women makes the counterplan functionally unpredictable and not researchable because we cannot generate offense against it or contextualize arguments in the plan versus the counterplan. It's a voting issue for reasons premise ground picks are bad, they're fully aggressive, they can pick out of any minute aspect of the plan. Also, the choice comes in the back because we lose the right to permutation, then we can't have any offense against the counterplan. It also encourages vague plan writing because it forces us to simplify the plan. It's voting issue reasons premise ground dispositionality is a voting issue. The choice comes in the back and negative gets to defend two different rules simultaneously while the applicable gets to defend one. That's the same as conditionality. If we straight turn the negative, can simply say that the counterplan is no longer net beneficial, creates a moving target because we're forced to argue against the world of the counterplan status quo. It's a voting issue for reasons of premise ground. Additionally, it doesn't solve Solomon 99. The court implicitly acknowledged it hit the court's version of the signal lack of guiding principles in the lower courts. Courts without ad hoc distinctions avoid confusion prior precedent. The distinctions that themselves promise to cause further confusion and federalism precedent needs an explicit overrule pertaining to the elements of course of pain to distinguish whether an overall has to true precedent is reluctant to explicitly reject precedent left open somewhat ambiguous marker of things to come and permutation do both and states will solve gold shield in 2 cases. Several states have introduced versions of 94 civil rights with authorized versions of the same cause of action state court. However, we recover may be curtailed by restricted statute of limitation, the absence of pre-chill, protection of state evidence goes or other procedural obstacles. State remedies offer no relief for those who are in the claim are limited by local bias in case which are provincial bias of the local law enforcement officials and plan is key to funding for the states. Hagen and 2K1, although the Morrison decision applies only constitution of Title 3, many senators use the decision like the entire agreement of Iowa 2. For instance, the severe step back to the movement to eradicate mass violence because without the enactment of Iowa 2, the funding provided states for will not be authorized. The death of the Title 3 can only destroy its only effective alternative comprehensive state action. And states also helping the world account plan goal for 2K2. The attitudes of state judges personal will shape and deeply create sexual inventory stereotypes of custom victims of rape and domestic laws and condone trivial to our crimes. These attitudes are so entrenched that even the states have dramatically reformed their rape and domestic statutes and of course remain profoundly inadequate in the absence of all states seem to bring about general improvements to the right of response to gender motivated violence were largely stymied by civil rights when they had the potential relief. The background can see significantly absence of the federal civil rights when they provide victims with alternative overburden. So the courts additionally they can see our now evidence indicates violence is high in the status quo. It proves that their state courts would not be able to solve for gender violence, otherwise it would be decreasing in the status quo.
All right, on the poverty, let's just go with poverty.
Sure.
Why is the Child Support Recovery Act, how is that not just one symptom of the larger problem of poverty? Like, I don't understand how you create this causal link.
Sure. We read a piece of VA evidence that indicates the critical component to solving poverty is getting a skilled labor force, and which requires getting people back into college and also give them monetary restitution.
So you're saying that now the child, if I'm understanding correctly, the child support recovery is like when a dad, like the ability for a dad to pay a family.
Yeah. The Child Support Recovery Act ensures that if I, for example, if I impregnated a girl in Kansas and ran off to Missouri, in the status quo, I wouldn't have to pay it because it crosses state lines.
Right.
The Child Support Recovery Act says I can't do that, and I would still have to pay.
How is that the linchpin of the labor force?
Well, our evidence indicates that a lack of the Child Support Recovery Act has hindered abilities for mothers to get their children into college and for them themselves to get better jobs.
Aren't there a million other alternate causalities that prevent kids, like lower income kids, from getting into college?
Well, I mean, I guess that this may or may not, I don't know, the only evidence read in the round so far, it seems to indicate that the plan is a critical.
I'm not saying that it's like the opposite. I'm merely saying, is your evidence,
our evidence, I think,
your evidence being conclusive on this subject?
I think our evidence is pretty good on this question.
Okay. On the Luke evidence you read, right? His argument is against quietistic postmodern Taoism.
Kind of. We read two pieces of Luke evidence. Oh, I don't know if this was your question. I don't know.
No.
Okay. The first piece of Luke evidence we indicates that environmental management is in fact inevitable, and we need to curtail corporations that are collapsing the environment. Our second piece of Luke evidence indicates that individual solutions to environmental problems will ultimately fail because he provides the example that even if you buy eco-friendly light bulbs or an eco-friendly toilet, it may make yourself feel better, but it won't do anything for human survival.
And then on the, all right, just quickly to clarify, did you read both?
No, just the top part.
Okay. And then, when Lifton's talking about this, right, like, when he says you should imagine the end of the world, what does he mean by that?
He says you should imagine that nuclear destruction is upon us, because then...
Right, but does that mean, like, I mean, y'all didn't really do that, but, like, does that mean that we need to be, like, nuke war, like, and that leads to nuke war? Is that his conception?
No, not that you should say everything leads to nuclear war, but his argument is when you feel like survival is impending and we're all about ready to die, everybody learns to take steps to stop that impending doom. So
right, but his argument is that for the value of imagination, right, is that you shouldn't distance yourself from the conception of nuclear war, because that's what makes it.
Sure. I mean, he is talking about nuclear war, but it's a parallel.